Good morning. Good morning, everybody. If folks could please take their seats. I apologize for the setup of the room. This is the only way we could get 90 people in a room that had space to write on a table. So I invite you to turn your chairs around. I apologize that this is the way it is. If you're more comfortable on the sidelines, feel free to sit wherever you're comfortable. My name is Geeta Kapai. I'm the tribal liaison for the state and regional water boards. I welcome you all here today, and I want to start off with a prayer from Donna Begay.
Tumaduk, good morning. I want to thank you all for coming, and really appreciate the water board for hosting this event for us today in a good way. My mom's side is Tabatalabo from Kern Valley. We have 3 bands, the Pakanapul, the Palagay-Wanap, and the Bakalanchi. And I'm going to speak in our Pakanapul dialect. And I'm going to just do a blessing prayer for us this morning. And hopefully we have a good day today. So, Tutukal is good day. Ma Pangatau Ma, hello the one above, hello. Alsana Meligich, bless our gathering. Alsana Adivish Tamich, bless our children. Alsana Swal Tipal, bless the land and the water. Alsana Teliwich Penny Omo Hits, bless the circle that connects us. Alsana Tutudal, bless this good day. Alsana Pungatal Tawu Pungatal, thank you the one above, thank you. Aho.
Thank you, Donna. I'd now like to introduce, come on in and have a seat. I'd like to introduce our chair of the water board, Felicia Marcus.
Thank you, Geeta. Good morning, everyone. Glad you're here. And you all, I suppose Geeta needs no introduction. I have to say, coming to the water board, I was delighted to see people who had so much love and respect for working with tribes. And so Geeta is a godsend along with her staff. It was nice to come here and already have that be the case. I'm going to see a number of you through the course of the week through the EPA Tribal Conference. I know some of you through the years from having originated that conference like 20-something years ago when I was at EPA. And so for me, those conferences are a labor of love. And the fact that it's in Sacramento makes me very happy because it means I can go to various parts of it. But since I'll be speaking later this week, I'll just be brief this morning and tell you how happy I am that you're all here and happy that we were able to put this on. I was amazed at the response we got to this. It was a request that many of you had made at the last Water Summit. We had done this training one time before. Of course, many of you have federally reserved rights or federally recognized. Others of you may well have state water law rights. Tribes have elected to get them. And more importantly, it is important to know it in working with your neighbors. And the fact that so many of you were interested was terrific. And so was the fact that so many water board staff also wanted to attend. I'm not sure what that all means. I think that's more about you than the desire to learn water rights. I'm sorry, Mariana. I think that's probably true. And that makes me very happy. I will be talking later this week, so I won't go on at length, but those of you who know me know that my work with tribes in the 90s is probably the most important work I'm ever going to do in my life. And there we had a trust responsibility and a lot of relationship mending to do as the federal government. But I was really thrilled to come into state government at a time when the governor had issued an executive order directing his agencies to work with tribes and to consult with tribes. And so it was a very comfortable place for me to come. So although we don't have a formal trust responsibility with you, we do share a responsibility to the people we all serve, and we do want to be in partnership to you. So thank you for coming here, and thank you for your interest. And we obviously look forward to working with you. Many of you we have been working with. There are issues of tremendous import that face us, whether it's water quality, cyanobacteria, which you'll hear more about today and which many of us are working on together, or even flows for fish, which are precious to us all, and a challenge, as you learn through our process, to actually achieve. So I'm glad to have you here, and perhaps you can help us think some of these things through. A host of other issues going on through the drought. I've no doubt talked with some of you on the monthly webinars that we've had, or Tom Howard, our executive director, has, or with your chairs. And I had the opportunity to meet with a number of tribal chairs in concert with Native American Day a couple of weeks ago, and it was truly an honor. One of the issues we have worked with you a lot that you'll also hear about today, and we have the staff that have been working on it, is the issue of beneficial use designations. This is one of those interesting, remember what the point of it is experiences. We talked about doing statewide beneficial use designations for cultural practices and subsistence fishing. We were very enthusiastic. Region 1 has already done that, and we said, well, we'll just go ahead and do it at the state level. And then some of you reminded us that even though it might seem like something that's great for tribes, consultation means consultation. So we've spent the last number of months meeting in Northern California, Southern California, with individual tribes to look at it. We have a number of resolutions from tribes. We don't necessarily need them, but it's wonderful to have them. And I think we're closing in on being able to make these designations, which are things that you all can use off into the future as regional boards are integrating different uses into their standard setting. It may seem somewhat arcane, but it is a tool we hope that will be of use to you, but also reflect reality, which is something we kind of like to do, but we don't always do. So it's one of those things where, having been challenged by you to do that, we are definitely working on it. So without further ado, I'm going to hand this back to Geeta and let the day begin. I'll look forward to seeing a number of you later in the day. I'll try and come back. I'll come back in, and certainly throughout the course of the week for those of you who are staying for the full Region 9 Tribal Conference. And I very much look forward to getting to know those of you that I haven't met, and I hope that you make a practice or make an effort to meet each other, whether it's the water board staff or tribal environmental leaders. We definitely want to create the relationships that it takes to get this work done. So again, my thanks to you from the bottom of my heart for what is really work of the heart, working on water for the people and the land and the critters that we all serve. So thanks again. I'll look forward to seeing you all throughout the course of the week.
Thank you, Felicia. Anyways, good morning again, and I want to thank you all for joining us today. It shows a real commitment to learn, and we need to learn, and I'm really glad that there's so many of you here. We originally had this scheduled for last week. We recognized after hearing from a few of you that this would be a good day to have it because you're already here for the tribal conference, many of you, and so I think that that helped us get the numbers that we've gotten. I'd like to first take a moment to recognize that we're here today on the traditional homeland of the Maidu and Miwok. I'd also like to welcome and recognize any honorable chairs, tribal elders, and councilmen that have joined us today. I'm happy to see this much interest in this training event, and I do thank you for taking the time to attend. We're very fortunate to have Felicia Marcus as our board chair. She has a long, dedicated history of working with tribes and recognizes the challenges and opportunities that exist within your communities. The training that's being provided to you today has an emphasis on water rights and water quality, educational and informational purposes, and does not really lend itself to policy-related discussion. There's other times that we can do that. This is an opportunity for the water boards to inform and provide you an overview of resources that we have available and how to access those resources. And I recognize that those policy issues about water rights are of concern, but hopefully we'll have those discussions at another time. Today has come about because of conversations we've had with tribes over the years and an identified need to demystify the California water rights system, among other things. And that's a tall order, but I'm sure Mariana Aui, part of our Office of Chief Counsel, will do a great job. It's an opportunity for you to ask questions. I would ask that you let the presenters go through their presentations and then save the questions for the end. Many months of planning went into this event, and I want to thank the diverse committee that provided input from tribes, our agency partners, and others. Thanks also to my staff and Donna Begay for leading the charge to make the event happen. The agenda outlines the activities for the day. So we'll begin with an overview of the California state government, the roles and responsibilities of the Water Board, and much of the day will be spent on the California water rights system. In the afternoon, we'll have an interactive opportunity for you to visit 6 unique stations in the mezzanine area. We'll cover information on the ERIMS, which is the Electronic Water Rights Information Management System, some water quality computer systems that you might like to try to determine in real time where you might have water quality issues. So if you are engaging in tribal practices, you would know, oh, okay, well, this area has a bacteria problem right now, real time. Or if you're doing basket material gathering, perhaps you may not want to put that material in your mouth, or if there, just things like that. There's real-time data that would be available to you. You'll also have the opportunity to learn about other resources and programs that might be of interest. We have a station on funding opportunities for tribes. And following that, we're going to reconvene in the meeting room and have a closing panel to talk about some programs and issues of interest, including the beneficial use designations that Felicia mentioned. And then at 5 o'clock, I hope you'll all join me in the mezzanine for a closing reception from 5 to 6. Again, thank you for joining us today, and I'm going to turn it over to Donna, and I look forward to the discussions.
All right. Well, back again here. Let's see. Can you guys all hear me okay? Yeah? Okay. I have 2 documents if you guys want copies of it. I have electronic here, and I also have an email that you can use to send me an email if you want a copy of the electronic version of the PowerPoint. So we're getting the little clicker going here. So this is my first time actually presenting on behalf of the State Water Board. I have 10 years experience working for Department of Water Resources, and then about 9 years working with the California Conservation Corps, and about 5 years involvement with the State Water Plan by Department of Water Resources. And I see some of these familiar faces out there in regards to the water plan effort. How many have been involved with the State Water Plan? Right. Okay, well, one of the reasons of preparing the overview today was some of you are on common ground with understanding, where the water board exists in our state government, and some of you, it's different, it's unique, it's different from the federal side. So I wanted to just provide an overview of the water management areas for California. Thank you, Gita. Okay, you have a handout like this, right? You've got a California map, right? That's the PowerPoint. There's also another document, it's a spreadsheet. It's a little matrix here, and this lists all the various agencies in the state and the federal that are involved with water management, including some of the federal agencies at the bottom of the list there. And this is the first time compiling a list like this for you guys, so there might be some edits that need to be done. Bear with me. But I wanted to try to put something in your hands so you kind of know, well, who do I talk to about water rights? Oh, that would be the water board. Who would I talk to about water supply, delivery, or reservoirs, dams, those kinds of things. Probably the other department, right? Department of Water Resources. So, okay, so moving right along. I'll make sure I can get this going here. Okay. There we go. Okay, so here's the PowerPoint here up on the slide here. The areas for the state management and the water area, you have the California voters, of course, the public opinion, your federal legislation impacts us, our state legislature, and all of that goes into the governor's office for consideration. But we're also seeing a lot of involvement by tribes. Recently, CEQA, there's some revisions to CEQA, some other legislations out there have been trickling down through the governor's office, and tribes are making a big difference in today's world. Natural Resources Agency, when we think about water, natural resources is definitely involved. And then there's the Cal EPA, the Environmental Protection Agency. And that's this particular building has all the 6 board of director offices. They call it BDOs. I try not to use too many acronyms here. So Natural Resources has the Department of Water Resources, and they're the ones that handle like the hydrology, the hydroelectric, the aqueduct, California Water Plan, They have all of these under natural resources. You have all these different departments like Fish and Game and the Lands Commission. This is natural resources. Then over to the right here is the California Environmental Protection Agency, which we have 6 board of director offices. Air Resources, Department of Pesticide Regulation, Department of Toxic Substance Control, Department of Resources Recycling and Recovering, CalRecycle, and Office of Environmental Health, Hazard and Assessment, we call it OEMA, and then the Department of Pesticides and Regulations there. And also, I have that twice, by the way. But at the very top is the State Water Resource Control Board, and we're under Cal EPA, okay? So there's a difference between where Department of Water Resources is versus the State Water Resource Control Board. Another comparison, real simple. Department of Water Resources is structured by hydraulic regions, so they have their breakout like that. We have our structure breakout by hydraulic region as well, but also by decisions that have to be made and by the climate and those kinds of things. So Department of Water Resources, again, kind of a comparison of that department versus our department, so you kind of get a feel for what I'm going for is just an understanding that you're in the right room because water rights is here, water quality is here, safe drinking water is here. These are the issues that we deal with. Beneficial uses is here. So again, that's pretty much where we're at with the structure of that. We also are involved with planning at our region level, water quality planning. There's also we have participated with the State Department of Water Resources California Water Plan through the California Native American Tribal Engagement process there, participating on the Tribal Advisory Committee. We have various other planning tools as well, including our own Water Board strategic plan. Moving right along, again, here we are in the state government under Cal EPA. We're located under Cal EPA. Today, I think there's going to be a process here where we can find out too, how do you issue a complaint? How do you find out more about us? This is kind of the chain of command in the sense of there we are, the State Water Resource Control Board. You can always talk to Cal EPA and of course the governor's office. So it's always good to know how do you communicate if you have an issue, right? So that's going to be discussed a little bit more today too. Finally, this is our new revised organizational chart. We have a new division of drinking water. It used to be under the California Department of Public Health, and it now is one of our divisions. And so you can see the kind of the structure there of our various divisions there. And of course, we have here today with the Division of Water Rights, we're going to have our presenters that are going to focus on certainly that topic. And then we also have water quality folks that are here today as well. So this is our structure. Felicia is way up at the top in the green box. That's our board. And we also have our regional boards on the right there that are representative of the geographical areas. And then, of course, our operations. And we have our executive director, Tom Howard. He's the guy that's actually in charge of the entire department. So what I wanted to bring up is this matrix of the idea that I got here is I was reading all the roles and responsibilities for all the agencies, all the departments. And so I started to collect common themes here that I was seeing in the support circle and operational responsibilities. So I was able to narrow it down to these few areas here. And so comparison, you can see there's on the top here is the Natural Resources Agency, Department of Water Resources, what they do in comparison to what the State Water Resource Control Board does, as well as at the bottom there is the new Division of Drinking Water, bringing them into our water board. So just kind of a matrix used to kind of identify who does what, okay? Just a little bit of history, I'm going to wrap up. The Native American history some of us have experienced. I know through my own research, working at the Smithsonian at one time, got this picture of my grandfather, and he's with J.P. Harrington, one of those linguist guys that traveled around California, right? And so in here is the aspects of from my great-grandfather notes that, you know, the native people that he was aware of down in the Tejon area and Kern Valley area, they did agriculture, irrigation, water supply. You know, they were concerned with all of these things. They used water for transportation. You know, they dealt with seasonal droughts. You know, so we have records of these things. We also know in the 1850s we had a lot of impacts here, livestock and man-made conveyances and levees and floods and hydroelectric and gold mining all played a significant role in today's framework of how we manage our water here in California. But doing full circle, knowing the native perspectives, we're starting to bring that more into the additional elements to water management, such as protecting our cultural resources, make sure we have a tribal affairs and liaison office where needed in our organizations. Tribal land trusts are starting to come about. We're even starting to put the tribes, you know, involved with the water quality, the water rights, certainly that by today's training. But more importantly, too, we're also getting mapping going, too, to know you guys, you know, where your tribal lands are at, you know, the allotments, the rancherias, you know, all of that's important, as well as layering it with our regions so we know how to outreach to you guys, okay? So anyway, coming together, this is the kind of the introduction, hopefully California State Water Management, you know, 101. So that was your crash course. I don't know if you have any questions, but I would like to really defer most of the time here now to the water rights is why you came here. So I wanted to make sure you guys had that framework at least to work with. Okay, thank you.
Thank you, Donna. Next, I'd like to introduce Mariana Aui from our Office of Chief Counsel, attorney with our Office of Chief Counsel. Thank you so much. I'll give you that. Do you want? Yeah, I'll give you that one.
Is this working? Okay. I am not used to holding a microphone, so if I stop holding it so you can hear, please wave your hands or something. This is the second presentation I've given here in 7 years at the Water Board, so please bear with me. Thank you. My name is Mariana Aui, and I'm an attorney here at the Office of Chief Counsel. We have two sets of attorneys at the Water Board, and one of them does prosecutions of water rights violations, and one of them advises the board. And I'm on the side that advises the board. I attended the first Tribal Water Summit in 2009, and that was really the genesis for this training. We had a training about 2 years ago that I know at least one person in the room attended. So we've tried to incorporate feedback from that into this training. And we've also used what people have asked for in terms of topics and an overview to inform what we're talking about here. This is an ongoing conversation, though, so if there are things you would like to see covered in future trainings, if you want to come up and have a conversation about a different topic when I'm not covering here or when I'm just sort of giving a glancing blow to, you know, feel free and we can discuss that further. Just a little bit about myself. I am the point person in the Office of Chief Counsel for tribal water right issues. I took a few classes in law school on Indian law, and I worked at the California Indian Legal Services as an intern when I was in law school. And I have had some experience after graduating from college working with the Western Shoshone Defense Project out in Nevada on a lot of land rights issues. So I have a little bit of experience, and I've been involved somewhat in this greater effort that the water boards are now making to have more of a dialogue with tribes. And so hopefully this can be a useful part of that that ongoing experience. So, here's my clicker. So Donna gave a great overview of one of the most confusing things about the State Water Board, which is what exactly is it that the State Water Board does, and why is there also a Department of Water Resources, and why when you have water, that's one thing is, flood planning's over here, and long-term planning's here, and delivery's over here. My part of the training is water rights. And so this is the Division of Water Rights' mission. So within the State Water Board, there's a separate division of water rights. And the goal is to establish and maintain a stable system of water rights in California to best develop, conserve, and utilize in the public interest the water resources of the state while protecting vested rights, water quality, and the environment. The focus of water rights is about who can take water out of a water body and use it for some beneficial use. That's like the basic crux of what water rights is. So what can people dump into the water? What's going to happen with your runoff? That's Division of Water Quality. Is there water when I turn on my faucet? Do we have water actually available as a source? That's a combination of Division of Drinking Water and Emergency Services. We've been doing a lot of coordination around that in the drought. Hopefully that's not something you've had to become too familiar with this year, but I understand probably some of you in the room have. But water rights is about who can take the water out of where it occurs in nature. So this is just an overview of where we're going to head with the training over the next 5 or so hours. So first we're going to talk about what is a water right. This is actually a pretty fundamental question. It's something that it's 2 words that everybody thinks there should be a shared understanding of, and it actually, when you get down and start looking into the details, it becomes quite complicated, particularly in California, and particularly with tribes. So we're going to spend some time looking at that question. Then we're going to talk about what are different ways that you can assert and protect a water right. One of the topics that people were very interested in is, okay, we have a water right, we have a claim, we aren't getting the water, what can we do about that? And so that's part 2. We're going to be talking about a lot of processes for that. Part 3, we're going to be talking about in-stream flows. Felicia talked about this briefly in her introduction. This is one of the biggest questions that people have is, okay, we have this water right system that says who can take water out of the system. How does that interact with leaving water in the system for in-stream needs? The first 3 topics, I'm going to focus almost exclusively on surface water for 2 reasons. First of all, 90%, probably even 99% of what the State Water Board does is surface water. Our authority, the majority of our authority, is over surface waters, and the majority of state regulation is surface water. Surface water law is also very, very, very similar to groundwater law. So if you live in an area like much of California that does not have a lot of surface water, you can't just doze off here and wait until the end, because there will be concepts that we're drawing on in the first 3 sections that are going to be fundamental to understanding what's happening with groundwater. And I'm going to touch just really briefly in the groundwater section. I'm sure a lot of you have heard about the new groundwater legislation that passed, and I'm actually going to be giving a panel on that at the EPA conference. I'm not going to talk a lot about the legislation here because I know a lot of folks are going to be going to both. And, but if you want to talk about it more, please, feel free to come talk with me. I have a handout that I think everybody should have gotten that has at least the important dates about that legislation. So I know not everybody's going to be here for the whole conference, so I don't want to leave everybody totally hanging, but I don't want to make a lot of people sit through something twice. And also I have a couple points in the training at which, you know, I have like a stop and break for questions. So basically after each one of those Roman numerals, there's going to be a big question break. So we aren't going to wait till 3. There are going to be certain pauses. If there's something though that absolutely can't wait, then it can't wait, and we can see whether it makes sense to address it in the middle or wait till we get to one of those big slides that says questions. All right. So I am a lawyer, and I like disclaimers. This is one of my areas of expertise. So this is a very broad overview of very, very complex material. There is a reason why people get a lot of lawyers involved in water rights, and it's because they're very, very complex. My sort of goal in setting up this presentation and thinking about what's going to be most useful for people, what makes sense to do at sort of a broad introductory level, is to get some of the language down, get some of the ideas about what is possible, have some examples about what's been done, and discuss them. But this isn't, individual situations can vary widely. And so this should be sort of a launching point, a way to help understand and inform future conversations. I would feel very bad if anyone relied just on this presentation to then go make and implement a decision, because there's so many individualized factors in every water rights decision that need to be thought through. And also, the PowerPoint presentation, we managed to do that as a handout this time. That was a big request last time, was to get the materials out earlier so that people could have a look at them. But I'm very wary about people relying on just the PowerPoint, because all this talking that I'm doing is going to have a lot more disclaimers in it. There's going to be a lot more sort of context and discussion. So I just want to say, you know, think of the PowerPoint and this presentation as a whole as just broad strokes, and hopefully it's useful as that. And also, I apologize. I've tried to add a few more pictures in here to help keep people awake, because I know that this is not the world's most engaging format. But I'm not an artist, and I'm afraid it might show. So we're going to step up here to the first section about what is a water right. So first we're going to go over some differences with other property rights. What are some of the ways why when we say water right, it means something considerably different than when we talk about other property rights. Then we're going to talk about some of the elements of water rights. And then we're going to give a brief overview of the 3 most important kinds of water rights in California. We're going to talk about appropriative rights, riparian rights, and then winners' rights, which are federally reserved rights specifically for tribes. Is anybody here claiming water in the San Diego or Los Angeles rivers? Okay, there's a special kind of water rights called Pueblo water rights that really only has an effect there. I'm just going to skip over that, as was the plan. I'm sorry, I couldn't hear the last part of that. Just through San Diego, or just the San Diego River that flows through San Diego? Yeah, not the whole county. Okay. Sure. Yeah. So it's the same. There's a federal law of water rights that also gets recognized in California. So that's That's the winner's rights, the Federal Reserve rights. So how is having a right to take water from, is this a, yes, pointer, from a river different than having a car? So the take-home point of the next 3 slides is basically that water rights are very limited. They're highly regulated compared to other types of property. Not all of the things under your water right are going to apply to all types of water rights that we're talking about, because that would be too easy. But this is just to get a general idea. So your car, you have a piece of paper, it has your name on it, that car is yours. The car belongs to you. With the water right, it's something called a usufructuary right. You don't own the water. You have a right to use the water. And the water is owned by the state. Or in the case of a federally reserved right, it's unclear where ownership of that water lies. It's a question that hasn't been answered. But it's probably not your name, like on the title of that car. You have the power of exclusion of that car. If you don't want your kid brother who doesn't drive well to drive your car, you don't have to let him. Your water rights are shared. If you're not using that water right now, you can't stop someone else from using it, no matter how they drive. Your car, you can use it when you want to. If you want to go to McDonald's at 3 in the morning, the 24-hour drive-through, you can take your car and you can just go do that. Your water rights, you aren't guaranteed like that. You could go out and say, I want water now, and it's not actually available there for you to use, even though you have a piece of paper that says you have a water right. Your car, you can use your car to commute back and forth to work every single day, and that's all you use it for 10 years, and then you decide you're going to drive it to Nebraska, and you're going to go visit your family. And you can do that. It's your car. Water rights, you can only change what you're doing with the water in certain circumstances. There are limits on what you can change about your water right once you've been using it a certain way for a long time. You don't have to use your car. You can sit your car in your garage and just wax it every day. You can put it up on blocks in your yard and just leave it there for a few decades. And you can do that. And then it's still your car. But if you have water rights like that, a lot of times your right to lose the water will go away if you're not using it. Not all the time, but some of the time. And your car, there is a limit in what you can do with your car. You can't do absolutely anything with your car. You can't, like, I don't know if you've seen The French Connection, but you can't stuff the bumper and like the insides of the car full of cocaine and use it to smuggle internationally in a drug ring. You also cannot use your water right to say, like, run a mill and grind up a bunch of cocaine, if that's even what happens with cocaine. I'm a little unsure on the process. So you not only have to use it in a lawful manner, but there are a whole bunch of other limits on your water right. You have to use the water right for something that's beneficial. You can't waste it. You have to use it in a way that's reasonable given how everyone else is using water in the state. You can only use a water right insofar as what you're doing is balanced against what the good that water provides by just being where it is in stream. And you have to take the public interest into account with a water right. Now, again, these are state laws. With the federal rights, it's unclear to what extent these are actually limits on those rights. There hasn't been litigation on that. But this is just an overview of the ways that a water right is really different than another property right. And this slide is all the different things, not even all the different things. This slide is an overview of some of the many different things that can limit a water right. So if you do have, a piece of paper about your water right, it's typically going to have information about, who you are, the source of the water, where you can divert it, who in what order when there's not enough, who gets to divert water first and how you share, how much water it is in total, how much water it is as a flow, where you can use it, what you're allowed to do with it in that place, when exactly during the year you can divert it and when you can't. And then there can be a whole host of other conditions. You know, it can say, you can divert this water, but only if you have a fish ladder. You can divert this water, but only when the temperature is thus and such. So they can be an extremely limited right. And this is just one more beautiful slide. Here in the middle, we have a river, unmistakably. These stars are points of diversion. And you can see this river, I'm imagining, is flowing from the top to the bottom. And so you could have a city that uses water year-round. Their priority date is 1940, and they can use it, for people showering and stuff in the city. And then downstream, you have a water right for a pasture, and that has a 1910 water right. So the city actually has to let the water go by if the cows need it, but only during certain times of the year. So the cows can't have it all the time. I guess they're not on the pasture all the time. So that's kind of how some of those elements of a water right work. All right. Is that roughly clear? Because now we're going to start talking about the different kinds and how all these different elements line up in different types of water rights. But I just want to make sure, okay, I haven't left everyone behind so far. So appropriative rights, this is a kind of water right that is the most common type of water right in the Western United States. It is the exclusive type of water right in most of the Western United States, but not in California. It is based, you develop a right to use the water by using the water, putting it to beneficial use. It's based like so many things in California on the mining history. So the early miners weren't necessarily patient, law-abiding folk who were going to wait in line for permission for things. So they just came and took the water. And placer mines all across Northern California particularly. And the water was key to being able to extract the gold. The California courts upheld this method in a case called Irwin v. Phillips and said, yes, even though this has not been the law that you can just use water if you take it, we're going to say that that is the law. And in appropriative rights, this first in time, first in right means that whoever starts using the water first has more right to use it than anyone who starts using the water later. So the senior holder gets to use all the water that they've developed, a right to use and can use before the people next in line get any. After 1914, so in 1913, there was a huge piece of legislation called the Water Commission Act that passed. And it created the predecessor to the State Water Board, among other things. And it established that the only way to get one of these appropriative rights is by applying to the state. So no longer could you just go out and use the water. You have to come in, and there's a bureaucratic process. The priority date of the water, so how you tell who's in line, before 1914, it's based on when you developed a public intention to divert and use the water, which you then followed up on with due diligence. That's pretty wishy-washy. It's a vague limit, but that's what it is. After 1914, generally it's the date that you apply to the State Water Board or one of the predecessor agencies. So now there's for more recent appropriative rights, there's a much more clear time, okay, when exactly is this priority and who's first? Before that, there was a lot of uncertainty. So the State Water Board process basically goes like this. You apply to the State Water Board for a water right. That sets your priority date. And then the State Water Board evaluates the application and issues a permit, which says you can go ahead and start diverting. You can start building your dam. You can start building your canal. You can get your pumps going. You can plant your field. And then once the water's been applied, then you come back to the State Water Board and say, okay, I said I needed this much water to do this. I've now applied this much water and I've done this. And then we give you a license that says, yes, you've done what you said, and then you have a licensed right. So the quantity of your appropriative right is the amount that you put to reasonable beneficial use, and within the limits of your permit or license. So if you have a permit, so obviously within the limits of your permit or license is only for licensed rights. This doesn't apply to the pre-1914s. But if you have a water right permit that says you can have 10 acre feet, but all you've ever used is 5, you only have the right to use 5, even though your piece of paper says 10. On the other hand, if you have a piece of paper that says 10 and you've actually been using 15, then your right's only to 10. So it's the amount you're actually using that you're using reasonably and beneficially within your permit or license. Appropriative rights are use it or lose it. So after you've established your right, if you stop using it for 5 years and there's water available, so this isn't, there's a drought and I couldn't do anything for 5 years, or it would have been a really bad idea to do something for 5 years, but there wasn't water available for you. There was water available and you just didn't want to use it, you lose that right. And that's because of, the basis of these rights is using the water. And you can use appropriative rights for any reasonable beneficial use. They aren't sort of limited in terms of what you can use them for, except, the cocaine thing. And they can apply to flow that's naturally in the stream. They can apply to water that's been stored. You store up the water in winter and then use it in the spring, or it runs off of someone else's field and then it wouldn't have been there normally, but there it is, and you can build a right to that. And it can also be for water that's been imported into your stream system. So we have a lot of systems that are that move water from one natural watershed to another in California, and you can develop appropriative rights to that imported water. I saw a hand. If it's something that'll make it so that you don't understand what's happening next, we can ask them in the middle. Otherwise, I'd appreciate it if we could hold to the question slide. Is that okay? But seriously, if you're not going to understand what's coming next, I want to, okay. Yes.
Since you're talking to tribal people, can you talk about first in time regarding tribes, because they're first in line?
Yes.
And also, if they aren't federally recognized, how is that impacted in terms of you have to apply? And also, if let's say fish aren't there now but came in later, how would that be seen in that context? I'm just wondering, when it comes to first in time, how complicated it gets.
If it's okay, I might hold the fish question, because I think that's going to make more sense later when we're talking about in-stream flows. So the question about tribal peoples as the first peoples here in California, so if there is an appropriative water right, and I'm going to be talking about two other kinds of water rights that are established very differently later. But just talking about an appropriative water right, if a tribe has been using a water right that meets all these elements. So if your tribe has been diverting from the same source of water, all these don't actually have to be exactly the same, but roughly, if you've been diverting from the same source of water, the same amount, sort of, again, there are caveats there, for the same reasons, using water in the same place since before 1914, you can establish one of these water rights if your use has been continuous. So it's so hard for me not to go into all of the details, which I don't think would actually be the biggest service right now. But I think the broad answer to your question is, yes, tribes can certainly have these rights. You do, and they will certainly be recognized by the state. But the fact that a tribe was here first isn't a factor in discussing an appropriative water right. It's the water use being first. Does that make sense? Okay. Okay. Sure. Okay. Okay, wait. Where were we? Okay, and this is about changes in the water rights. So appropriative water rights, you can only change them. So all those different elements I was talking about and sort of stuttering around about where exactly you would have to show change and stuff. That's because of this thing, the bottom bullet here, which we refer to as the no injury rule. So you can actually change your water right. If you have a licensed right, you have to ask us ahead of time. If you have a pre-1914 right, you can just go ahead and change your water right. A lot of those different elements within certain bounds. You can't change the source. You can't change the amount. You can't change the season. Those are things that essentially would create a new water right. But you can change what you're doing with it, where you're using it, and things like that, as long as you aren't injuring other legal users of water by doing so. So that is the flexibility within that rule is based on injury to other people. Yes. Let's go back to my cows. Okay. So let's say they double the number of cows, right? So they have a senior water right. 1910 is before 1940. They have a senior water right for this pasture. They double the number of cows. So it's the same place, it's the same person, they're just crowded now. And so they need more water. Now that's a change to the water right. And they can't tell, hey, city, you're gonna have to pass us more water under our 1910 water right, because they haven't established that right. The city built their city relying on the fact that there were 40 cows there and now there are 80. And so the city doesn't have to change what it's doing to accommodate 80 cows instead of 40. Or let's say a cow pasture wants to move up here. There's better grass up there. So they can change the point at which they move it, but only if it doesn't actually hurt the city. So if them taking this water out here means that the city's intake can't get as much water as city needs, they can't make this move. If it doesn't hurt the city, then they can make that move. Does that make sense? I can't remember who asked the question even now. Okay. 2 more.
Most tribes.
Pardon me?
Do it in reverse because that's what affects most tribes, junior and senior water rights.
Yes. Okay. Yes. So same thing. So let's say your city, let's say they want to, the problem is if they move where they're doing stuff, it doesn't really affect this person. So let's pretend that this is a city and this is a cow. So if this was a city, the city couldn't move its water right in a way that's going to hurt the cows being able to get water. Then it's actually outside of their water right. I realize that, as I said. That's a kind of change you can't make because it affects other people.
Mariana, I have 2. There's one here and then there.
Oh, there was one here too.
Yeah, came after.
Okay. If an entity or a business had a water right, in this case I'm talking about a mill on the McCloud River. They had a water right to that water, but the mill has been closed for a long time. And so the first part of the question is does that right still exist because it hasn't been used? And the second part is new people have bought the mill and they're claiming that water right and they're going to repurpose that right for some other type of development. Is that the kind of change that you're talking about here?
Yes, that is exactly the sort of change I'm talking about. So to answer the first question, if this is an appropriative water right, which I don't know, oftentimes a mill could be something on a riparian water right, which is a different set of rules. But if it's an appropriative water right, you would definitely want to look into forfeiture if they, whether that water right still exists, and you would want to look into, if that new use was going to hurt you or affect you in a way that's different than the way that the original, mill use would have affected you, then that no injury rule would apply if it's an appropriative water right.
So my question is just kind of on the clarification of injury. Is that like pertaining to, say, a user's water right to economic gain and capital? Like, would that be considered injury? Say, something that you want to do in the future affects that gain or, the economic gain that people get from having a water right. Would that be considered injury? Like if
it would be, that's an interesting question. So for appropriative water rights purposes, it would have to mean you can't use as much water and you can't use the water for what you had developed the right to use it for. Now, if you have a water right like a federal reserved right that can sort of cover future uses, which I think pretty soon I'm going to knock off the lines of questions because I think it'll be easier. I think the questions will be more helpful to people after we've had an overview of the different types of rights. But if you have one of these rights where you can have this future use, it's an interesting question how the no injury rule would apply to that, because you have this tension with, well, if you aren't using it right now, you can't control what other people do with it right now. So if it's not causing an actual harm right now, it's difficult to see how the no injury rule would apply. But the question of a future use of water versus a current injury, as far as I know, that has never been addressed. All right, one more, and then we're gonna.
I'm on a reserve for after a couple slides.
Okay.
Because there's some riparian stuff too that deals with this also.
Yes. Okay.
Before you go on, housekeeping. I forgot to mention the restrooms are down the hallway that way, and cafeteria on the first floor. Feel free to go get what you need. Sorry. This is a state agency. I tried to provide coffee. It didn't work, but I am hosting a reception in the afternoon. My apologies. I will have a water station at the back of the room for you, but I couldn't afford $1,000 for coffee this morning. Sorry. This session is being webcast. So if folks back home want to patch in and listen in, send them a message. It is being webcast all day. You can get through it through the Cal EPA website or the Water Board's website. Look on the audio. I believe it's both audio and visual video recording. So let them know. Thank you.
Okay. Sure. All right. So we're going to go to another picture of appropriative rights. So just to emphasize, these are rights where you can have things like a storage reservoir, and you can transfer these water rights far. So the place of use isn't limited in an appropriative water right. So you can, does anyone know in California of a place where there might be a large reservoir and then that water is transferred over a mountain range? That is an appropriative water right. And this is just a first in time, first in right. Mine, 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 all mine, 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 mine. That is how appropriative water rights are treated. This is what a license looks like. I know these are hard to read when you have them in your hands. I knew that there was no chance that anyone would actually be able to read them, but I just wanted to say you can, this is one that was actually taken over later by a tribe. So this is now a tribal appropriative water right. And I don't know, maybe you can possibly see it has things like, here's the place of use. You can see like all these acres and all these places, and it has an amount on there somewhere, what I can't even read up here. And it has some conditions, and then it has, some more conditions and a date. That's gonna be the priority date. If you want to actually be able to read any of those, the ERIMS discussion that's going to be later, they're going to have a computer set up, and you can actually go and look up all of these water rights. They're all available online, at least the ones since 1914, because those are the only ones where we have things like this. So moving on to riparian rights. So riparian rights are based on a completely different theory than appropriative water rights. Appropriative water rights are based on, I used the water and I used it first, it's mine. Riparian rights are based on, I own this land. This land is touching the water. This is a natural water body, therefore this water is mine, but I have to share it with you. So it attaches to natural water bodies, but it can also, water bodies are changing all the time, right? So a river can flow one way, and then there's a big flood, and it moves over to a different place. And so there's kind of a fluid, if you'll excuse the use of the word, definition of what is natural. So if somebody has engineered a natural stream so that it flows a different way, say for flood control purposes, and then that new water body can start to be treated as natural in the law. So it can actually be a rather difficult question in this very engineered water world in which we are now to tell, okay, is this natural enough for there to be riparian rights to something? So that's going to be one of your questions with riparian rights. The amount of a riparian right is squishy. So appropriative right, it's like, okay, this is what I've used. This is what I've applied to beneficial use. This is how much water I have a right to. For riparians, it's what's reasonably needed for use on the riparian parcel within the watershed. So you can't use this riparian water. You can't take this riparian water over the mountains. You can't even, there might be parts of it. You might have a large piece of land that you bought, several parcels of land, and then put them under joint ownership. Well, only the one that originally touches the water is the riparian parcel. And you can only use the water on that piece, even though you might own the field next door too, and it's within the watershed, but your riparian right is going to be limited there. And it's a shared use with other riparians. So instead of mine, cat, it's when there's not enough to go around, everybody sort of has to collectively cut back. So it's a different theory. It has some problems in implementation sometimes. So with other riparians, you have to share. But what do you do with someone who has an appropriative right? So they aren't into sharing. That's not what appropriative rights do. And so to put this into an absolute priority system, you use the date that the land was withdrawn from the public domain as the sort of de facto date of priority for a riparian right vis-a-vis other rights, but not vis-a-vis other riparians. Is everybody confused? Because if you are, that means it's working. Thank you. That is correct. Use it or lose it does not apply to riparian rights. So very unlike an appropriative right, you can not use your riparian right for decades and then decide, hey, I think I do want to try having some livestock here, and then and give that a try, and you can have the water rights to do that. And this is something I think I forgot to mention in the appropriative right. Appropriative right, you have to actually take it out of a stream to get a right to it. Riparian rights, it's actually a little bit unclear in California. There is some court decisions say that to have a riparian right, you have to be taking the water out of the stream. Other courts say you don't have to. That you can have an in-stream riparian right because the right is based on the natural flow of the water and the way the land and the water connect. No. So you can't transfer that riparian water right. So it's tied to the land in a way that an appropriative right is not. So it's based and kind of the rules around it are all about the land ownership and the land touching that natural water body, whereas with appropriation, the laws are all built around who's using the water first. Mm-hmm. So the question is, can a riparian right be changed to an appropriative right? No, it cannot. Yeah, they're two different systems. So the question is about how you know whether what people have been using under these different water rights. I'm actually going to get to that a little bit later, but I want to give you a brief answer now because it's a key point. And the key point is we know about appropriative water rights use since 1914. We know much, 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 much less. So we require reporting on usage for appropriative permitted water rights. We know much, 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 much less about usage under pre-1914 rights and under riparian rights. The kickoff section for the next section, we're going to be talking about the tool we do have to get information about those. So this is just that's going to be coming pretty soon. But yes, to add to the uncertainty, we have very little information on that. Where are we? Okay, and we've gone over the parcel, the smallest chain of parcel. So this, okay, and it's, okay, so back to the basis of this right. It's land ownership, it's what water is naturally there, what water rights might come with just sort of being right there on that land. It's the right to the natural flow. So you can't store under a riparian right. You can't get the big flows in winter and save them for summer. Your riparian rights do not cover that. And there's no right to what are referred to as foreign waters, which can be either water that, you know, somebody stored up in a reservoir and then released it later and they're done with it and it's runoff. You don't have a right to that water because it wouldn't have been there naturally under a riparian right, although you can develop an appropriative right to it. And if somebody is moving water from one watershed to another, you can't, in the watershed that it's moved to, that can't be part of your riparian right. Okay. So, okay. The question is, does that mean you get an increased allocation for your riparian use? And the answer is no. So even though there's twice as much water flowing by your land because someone diverted another stream into the stream flowing by your property, you only have the water right based on the amount that would have been naturally there. Yes. I will try to answer that question. Is it okay to hold that question until closer to the end? Because I really think that this having more of a basis of like what are, because it's a very, as you can probably tell, a very complicated answer. So I think it's good to get kind of a shared basis of like how are the different ways that that can work with the different water rights, because that's a toughie. Okay, so and then so a lot of the questions here are leading to how in the world are you supposed to have any idea what's going on with these rights, right? And so an adjudication is one of the few ways to get sort of to pin down these very squishy riparian rights. They can say, okay, you can get it just for this amount of water, just at this place of use, just at this point of diversion. And then any other uses, if you want to later get 500 head of cattle and put them on this land, then that can subordinate that right to other rights. So you can get some kind of certainty with these sort of two water rights systems through the adjudications process. Yes?
I have two questions regarding the riparian rights on trust land. If you have a rancheria that has parcels, say, subdivided by the BIA, it would be all one piece of land in trust. Would that not be able to move that throughout the reservation that's adjacent to the water right? Because the parcels are usually just made up by the local jurisdiction that we're talking about. And so I guess the second part of my question would be if you have a patchwork tribe that was terminated illegally if it's adjacent to a body of water, would it not still, the tribe be able to extend that water throughout its original jurisdiction?
I don't think that those questions have been answered with respect to tribes. So, I mean, I think the question, that's very interesting. The question is, so okay, here's that tube is a river. So you're talking about, where did Pointer go? Right, if A and C is a rancheria, I'm not sure you could. So if it wasn't a rancheria, you probably, not definitely could not. You probably could not. right? There are times when you subdivide and A can actually maintain that riparian right. So I think what you would have to do is really dig in to the specific history there about what happened individually with the tribes, who made these decisions about subdivision, and what, if any, of an original riparian right can survive termination and reinstatement. Now, those questions have been addressed in the context of federal reserved rights, but as far as I know, they have not been addressed in terms of riparian rights. But I have not researched that issue. So the eastern states, I've said the states in the West almost use, the appropriation doctrine exclusively. The states in the East use the riparian doctrine, and I have not looked at the eastern cases to see if that question has been addressed. That's very interesting.
If he was taken through condemnation, there may be some potential discussion later. A and C was one
Right.
for condemnation that succeeds through whatever.
Yeah, that would be an interesting question if how much of the rights associated with A were taken, or with C were taken through condemnation. And getting into sort of the details of when does A maintain a right, you look at whether this was addressed at the time the land was subdivided, whether there was infrastructure in place at the time the land was subdivided, or whether there were other circumstances that either historical or legal or on the ground circumstances that otherwise indicate a clear intention to maintain the right in parcel A. And I think that is going to be it's a very individualized question, even outside the context, the very complicated context of subdivision of tribal lands. And so I'm going to stick right now with that's a very good question with an unclear answer. I don't think you can count on having the right in A, but I don't think you can count on not having the right in A. Yes.
Yeah. So are most riparian rights, are they already adjudicated? And if someone has a conflict with an appropriative right, would that be a situation where it would go to court and the court would adjudicate the riparian right?
The next, so big Roman numeral 2 is about these questions. So here's all this stuff about what rights are. What do you do with that? I'm going to give a very, very long answer to that as the part 2 of my presentation. Okay. Okay.
Before you go on, so for those of you sending notes back home, the Water Board's website is www.waterboards, that's plural, .ca.gov. If you click on that, there should be a link to broadcasts. Is it, Diane, is it easier if they go through Cali PA's? I think probably, because you have to navigate. So if you go to www.calipa.ca.gov, there should be a link to web broadcasts, and you should see that here. I'll have one of my staff check as well and make sure it's live and running. So, oh, and while I have the microphone, I want to acknowledge my counterpart with DWR, the tribal policy person, Anacita Agustines. So for those of you that don't know, Anacita is on the DWR side. So go ahead. Thank you.
Sure.
Oh, and we're taking a break at 10:30. So when there's a natural break.
We're coming up on one.
Perfect.
Thanks. So briefly, let's assume, for purposes of this graphic, that A was actually severed from C, and then they were rejoined, and that A didn't maintain a right. Let's look at the sort of the limits of the riparian rights. So that would be you can't use it on A, even though they're under the same ownership. You can only use it here on C. And B over here can't use it on this side of these mountains. I don't know if you can tell those are mountains, but those yellow things are mountains, the yellow triangles. So neither the owner of A and C nor the owner of B can use this right on all of their property. And if there's not enough to go around, then they have to share like this. Forgive me, nobody's going to be able to read anything on this slide, I don't think. But this was the only map I could find that showed water bodies and tribal lands. And this shows only federal recognized tribes. I couldn't find one that also had the unrecognized tribes. But this just sort of shows, when you have the green right next to the blue, that there's the potential for riparian rights. There's Southern California. Okay, so now we're going to talk about winners' rights. And I just want to emphasize, very often, tribal members think that these federally reserved rights are the only rights that a tribe can hold. And that is not the case. So these are a particular class of rights that only tribes can hold, but that doesn't mean that tribes can't assert and hold riparian rights or appropriative rights. So anytime the United States reserves land to itself from the public domain, it is also reserving with that some quantity of water, if necessary. And we'll get into that if necessary as we go. So winters rights, and in fact, the entire doctrine of federal reserved rights all goes back to this case from 1908 in Montana called Winters v. United States. And the reason I'm distinguishing winters rights from other federal reserved rights is because there's certain things where a winters right might get construed more broadly than other types of federal reserved rights because it is a tribal right and because of the presumptions in federal law, because these are laws that are run through federal law, because of the presumptions in federal law in favor of tribes, and those are presumptions that wouldn't exist in favor of land withdrawals for other purposes by the United States. And I'm just going to give another disclaimer here. Almost everything in Indian law, as I'm sure you know all too well, is open to change. And this is our understanding at this point of what the federal law is. It is a different presentation about what's the state of these federal rights than I would have been giving 20 years ago if I had been a lawyer 20 years ago. And it's probably different than one I would give 20 years from now. So I just want to make a point that even though these are very long-standing rights, they aren't static. So let me see. I think what I'm going to have time to do is talk about the Winters case before we break. And then I'll come back after the break and we'll talk more about things that have happened since that Winters case was decided. So the Fork Belknap Reservation, way north on the Milk River in Montana, way up there, Milk River in Montana. There's a picture of it as it runs through the Fork Belknap Reservation. You can kind of tell why it might be called the Milk River. Hello. It doesn't want me to leave the picture. I'm sure you don't either, but back to the bullet points. So the Fort Belknap tribe had a treaty with the United States government that formed this reservation. It laid out a lot of information, but it did not mention water rights at all. There was a conflict with farmers who came to settle in the areas that the Fort Belknap tribe had left in order to go to the reservation. And there was not enough water to irrigate both on the reservation and on the lands of the settlers who would come into the territory. And so the question came, how do we handle this conflict? Who has the right to this water? So in a nutshell, this is how the Supreme Court looked at this. They looked at this treaty and they said, doesn't say anything here about water rights, but it is inconceivable that the tribe that was here, that agreed to move into an agrarian lifestyle on a much smaller piece of land than they had been living on for centuries, gave up the water rights that they had at that point, when those water rights would have been needed to be able to make a home out of this new reservation. There's no way that the tribe meant to do that. And it is inconceivable that the federal government, that has a trust responsibility for tribes, would have allowed the tribe to give up these water rights. And we're going to look to this doctrine. This is why I'm distinguishing winners' rights from later Federal Reserve rights. Treaties are construed in favor of the tribes. We know that there were language barriers. We know that there were serious balances of power. And we're going to go ahead and construe treaties in favor of tribes. And therefore, even though this treaty says nothing about water, it actually reserved the water rights. So that's the logic of the winners' rights. That is still the main case. It's a 1908 case. People definitely go back to that case today. There have been a lot of changes in the right, but I'm going to leave you there with that reasoning, and then after the break, we'll come back and we'll talk about starting out with that strong statement, what happened and where are the rights today.
Thank you, Mariana. So I think we're demystifying water rights. Right? And by the questions, I see people are really engaged and making us think. Break from 10:30 to 10:45. Let's resume at 10:45. There's some water and iced tea in the back of the room, and we'll see you in 15 minutes. Thank you. So if everyone could take their seats, please. I understand that the webcast is not currently working. We're working on it. We currently have webcasting within the building, but not external. We're working on getting it external, and as soon as it's up and running, I'll let you know. So if you could take your seats, we'll resume. Thank you.
All right. So, we're going to talk a little bit more now about what has happened with the winter's rights since the Montana decision. The winter's rights, as you can sort of tell from the reasoning and the logic behind them, are going to be one of the strongest and most flexible water rights. They're not lost by non-use, like an appropriative right. Most federal case law has held that you can change the purpose of what the water is being used for pretty radically. Wyoming, I believe, is the only state that has limited that and has said that in-stream purposes that the Wind River tribe couldn't shift using their agricultural right to an in-stream right. I believe that's the only decision holding that there's any kind of limit on that. It can survive termination and reinstatement. We talked about that a little bit in the riparian rights context, but I just want to emphasize here that there is very strong case law about the winner's rights surviving termination and then reinstatement. And to some extent, there's case law that says certain rights, for example, natural resources-based rights, can survive intact. If it's, for example, an agricultural right, something that can be more individualized, then it's possible that after an allotment was subdivided, if it fell out of Indian hands, then it is subject to termination. So that's kind of the broad outline of how that works. And a winner's right can be for in-stream purposes, or it can be for off-stream purposes. So the appropriative rights can't be for in-stream, except with a little twist that we're going to talk about later. But in general, they can't be. The riparian rights, it's a little bit of an open question. There's mixed case law. And then winner's rights, it's very clear that they can be for in-stream. The priority date for a winter's right. Now this gets into the question we had earlier about what does first in time mean when you're talking about the first people in California. If your winner's right is for a purpose that's new, that sort of came with the creation of a reservation. Now very often this happened with agriculture. A lot of reservations were created with the idea that tribes that were not agricultural would become agricultural. So if we're talking about a new use, then the priority date for that right is going to be the date of creation of the reservation, the date the land was reserved from the public domain in order to be a reservation. For ongoing uses, however, and a lot of times these can be the natural resources uses, but they may also be agricultural uses, domestic uses. There might be a time immemorial right for those, depending on a lot of circumstances about the creation of the reservation and the evidence about its purpose, and we're going to get into that a little bit more. And winter's rights are, vis-a-vis other rights, are first in time, first in right. So it's that cat on the pile of money, mine, 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 mine. Whoever's first, where you are in the line, that right gets filled completely before others get their right filled at all. The quantity of a winter's right is the subject of a great deal of debate and of most of the case law surrounding winter's rights. It's about, there's been a reservation established with a water right. Well, how much water is that? And the answer is as much water as is necessary to fulfill the purpose of the reservation. Now, that's how it was expressed in Winters. Later case law, a case called US v. Caporet, which we're actually going to talk about a lot, and I have no idea if I'm pronouncing that correctly, so if anyone actually knows in the audience, feel free to correct me. But that established the rule that the reserved rights are only to the primary purpose of the reservation. So this was a case that was about the creation of a national monument, what water was reserved when this national monument was created. And they said, well, the secondary purposes of this, the creation of this monument aren't going to be protected, but the primary purposes, well, we're going to say there's enough water for that. And the Ninth Circuit, so in the federal appeals court system, they have a bunch of different circuits. I think there are 11, maybe 12. And we're within the district of the Ninth Circuit. And so the Ninth Circuit has said that primary purpose rule does apply to winners' rights, but then when it's applied the rule in the Indian law context, it has found primary purposes. So it has said, okay, here's this rule, there's no water for secondary purposes, but there is water for primary purposes. And so they've sort of read primary purpose broadly in the Indian law context. So how in the world do you tell what the purpose of the reservation is? Well, the standard answer in case law is that you look at the treaty. Of course, in California, there aren't treaties. So the standard answer doesn't get you very far. You can look at the treaties that were negotiated but never ratified. They can sort of inform the decision, but they don't have the same sort of definitive weight that a ratified treaty would have had. You can look to the executive order that created the reservation. If there's any kind of signing statement, any kind of letters back and forth with the solicitor's office that sort of surrounded that, any communications creating that executive order, very often there's nothing. Very often those executive orders are about 3 lines and they don't have a lot of elaboration. You can look at laws that are related to the reservation. If there were specific laws about the creation of the reservation, you can look at reservation-specific background history. You can look at the general historical purposes of reservations, sort of what was the era in which this reservation was created, and sort of look at that to think about what the purposes of the particular reservation might have been and what kind of water needs that might have. You can look at the geography of the reservation. Is the reservation built around a water body? Well, that's going to definitely strengthen your case that there is an intent that the water rights to that water body be part of the tribe. And I know, no, I know. No, it's I'm guessing you're from the Wintu? Um, so, I mean, I think the larger issue at this point for the when-to, sort of the question you'd have to answer first before even getting to the question of what right could remain after inundation of tribal lands. Because it is entirely conceivable that there could be a water right that remains after inundation of lands. Now, entirely conceivable doesn't mean I have even begun to have the type of information you'd need to have to be able to think about the when-to situation in particular. But the federal recognition, I think, at this point is the bigger issue. It's difficult to see how a federal water right could survive in a tribe that's not federally recognized at this point. Now there's the reinstatement issue, so it could survive after reinstatement, but I think that's actually the harder question than the inundation question at this point. No. Yeah, and we're gonna hit. Yeah, we can. There, okay, there's some big limits on these. So these are big, exciting rights that people really want to hear about, and so we're covering them here, but there are serious limitations on whether any particular tribe can have them. And I think that's one of the biggest misconceptions about federal reserved rights is how common are they actually? And so the way I've set the presentation up is talking about that stuff at the end. So if that's okay, we can the end of the next like 5 or 6 slides or whatever. The other questions, are they for now or for then? Okay. Yes. The question is whether I can define public domain. And so the public domain is land that is held for purposes of so this is for purposes of the state, how the state looks at this. It's land that's held by the federal government and hasn't been released to the state or to any private party since the formation of the state of California. So we're going to be touching on that again when we talk about the limits of these rights. But it's land that hasn't passed into the state or private ownership since the formation of the state of California. Yes?
Withdrawn from the public domain, say Forest Service land, does it carry water rights with it no matter what land, say, might be withdrawn? Or is that something that would be determined by treaty, agreement, legislation, or whatever?
I'm not sure I understand your question. Forest Service land would typically have water rights associated with it that depend on the purposes of the creation of, that forest or potentially of the Forest Service if there's not, something specific about the creation of that particular national forest that would inform that decision. I'm not sure how the next...
Oh, well, what I'm saying is if a tribe made a claim on some land and that claim was honored by the federal government, would that land that is ceded to the tribe automatically have water rights connected with it, or is that something that's negotiated somehow or other?
I'm going to answer that question a little bit later, if that's okay. Because I think it makes sense to talk about quantification before talking about these other issues. So the quantity of water that you're talking about with a federal reserved right is dependent on this purpose question, right? So these are all the types of things, and this is not exhaustive. There's nothing out there that says we're only going to look at X, Y, and Z, and that's it. But these are the types of things that in case law have been looked at in determining, okay, what is the primary purposes of this reservation? Okay, so then you get a purpose. Well, that's still not an amount of water, right? So we're going to go through a couple of examples, because not only is there not a standard way to figure out what the purpose is of a reservation, there's also not a standard way to figure out how much water is associated with a particular purpose. So the closest thing we have to that is for agriculture. There's a United States Supreme Court case, Arizona versus California, which talks about the 5 Colorado River tribes and their water rights to the Colorado River, their reserved water rights. And it actually, this litigation goes through and actually quantifies the amount of water that was reserved for these tribes. So what the Supreme Court said to do is you look at the land that still has a reserved right. So we have the termination problem, the reinstatement problem. Some of that land has lost the right, and some of it has maintained the right. You look at the lands that have maintained it, and you look at what of those lands can be productive agricultural lands using current technology. So you don't go back to the time of creation of the reservation and say, okay, what could have been done with a pickaxe at this point in time? You look at today's technology with, electric pumps and field leveling and all of that, and say, okay, where is it feasible to grow things on this land with irrigated agriculture? You multiply that by something called a water duty, which is basically you need this much water to grow the crop you're most likely to grow in this area. And then you have a number. And Arizona versus California shows a very strong preference for using this standard, this practically irrigable acreage standard. It's also called PIA, because in environmental law, nobody likes to actually say the words. We just like to stick a lot of acronyms together. So which one, that standard, they said, we like this much better than something that was called the present and future needs standard, which was the standard that was the legal standard before this case came out. So where the primary purpose, or one of the primary purposes, is agriculture, chances are this is how that amount of water is going to get quantified. The present and future needs standard is the standard that was in case law that said, well, when the reservation was created, the amount of water that was reserved is the amount of water needed for the present and future needs of the reservation, which is logical, but putting it into practice is difficult. Who gets to decide what's needed, and what does future needs mean, and who can read the future anyway? Nobody could have predicted the green revolution in agriculture. 20 years before that, now what agriculture means can be something completely different than it meant then. Now what water needs are something that are completely different in a lot of ways. And so the Supreme Court said, we don't really like that standard. We want you to have something more like this, where you get a number and there's some multiplication.
So if a tribe's got a big ag tribe and they have more tribal communities, say they have 1,000 homes now, in 100 years they'll have 10,000 homes, they can't try to forecast what that 10,000 homes in the future will need.
So here we go to the next. Okay, here's a picture of the Colorado down by Fort Mojave Reservation. And here's another example. So if one of the primary purposes of your reservation is fishing, if the primary purpose wasn't to have an agricultural lifestyle, but it was to maintain a fishing lifestyle, then here are a couple different examples of how Federal Reserve water rights have worked in the context of fisheries. So the first case I'm going to talk about is a U.S. Supreme Court case, which is why I put it first. It's that case we were talking about before. It's not an Indian law case. So it's this national monument case, Devil's Hole National Monument. And what was happening there is there was a pool, an underground pool in a cave, where a fish called the desert pupfish was living. It's the only place that anybody knows that that fish lives. And so, and people wanted to study it. And other people were pumping groundwater. And you know, this one pool in this cave, the water level was dropping. And the Supreme Court said, no, when the federal government reserved this national monument, one of the main purposes was scientific study. That's the primary purpose. And scientific study here requires maintaining enough of this water in this pool that the fish can keep living there. So that was the amount of water, of that water right, is enough water in that pool that this one population of fish can live. So that's one way that a fish purpose to a federal reservation has been quantified. The next case is United States v. Adair. It's a Ninth Circuit case. It's about the Klamath tribes up in Oregon. And so this case said that the amount of water that was reserved and that survived termination and reinstatement of the Klamath tribes is the amount that's sufficient to sustain hunting and fishing as currently exercised to support a moderate standard of living, and not the full amount of water that was available at the time of the treaty. So again, like the practically irrigable acreage standard, it looks at the present. What are people doing presently for hunting and fishing? Just as people look at what are people doing presently for agriculture. And then it has this moderate standard of living in there that says, okay, we're talking about a time immemorial water right to a lot of water. And we're not going to say that all of a sudden nobody else gets any water. We're going to say you get enough for a moderate standard of living, but we aren't going to say you can be living high on the hog. That's what they said. So that's another quantification. And then the third example I want to talk about for a fisheries purpose, and this is something I think that is influencing my saying that inundation probably isn't necessarily the end of a water right, because this is up on the Columbia with the Colville tribes. The Columbia, as you might know, has dams on it that have not been kind to the anadromous fish. And so the water right that was found to have been created by this treaty was sufficient to have an alternate fishing ground, because the current fishing ground wasn't available for fish. And so this lake, which I unfortunately forgot to write down the name of, Otay Lake, I think, up there in Oregon, is they get 350, I think, acre feet a year for diversions to maintain this lake, which is not where they were fishing before. But that is how that was quantified. And so this, I believe, is more about your question. So what about the idea that the purpose of a reservation is a place for people to live and to be able to survive as a culture and as a community and as a sovereign nation? So that is typically referred to as the homeland purpose. And that is the standard that the Arizona Supreme Court articulated in the Gila River adjudication. And they said, okay, we're going to quantify the amount you need for domestic use, for agricultural use, for industrial use, and for commercial needs. And we're going to recognize that this could change in the future. So this is probably, the Gila River adjudication is probably the broadest interpretation in the country about what does it mean to have a federally reserved right. And there is the Gila River right before it gets to the Gila River Indian Reservation, or just north of there. So these rights are probably sounding really good. But we're going to talk now about some of the limits to the winners' rights. So the first key limit is that they're only for federally recognized tribes. And another key limit is that they're only on lands that are reserved from the public domain. So that means that if the BIA or the Office of the Interior or the solicitor bought some land from somebody to create a reservation, which was pretty common here in California, that land can't have a reserved water right, because this is a federal law that attaches because that land never came under the control of the state. And here's to your question: if the land was reserved for one purpose, and then say, the solicitor didn't buy it from a rancher in the valley, but the solicitor bought it from the Forest Service, then the amount of your reserved right is going to be the purpose of the original reservation. So if you have a right that is for agriculture, we've gone over this, I think, a couple times before, but it's worth repeating. So winners' rights, you don't have this due diligence problem, which means an appropriative right, you say, I'm going to do this with this water, and then you sit around and you don't do it. You don't get, your right goes away. It disappears. That doesn't happen with winners' rights, except if your reservation has been subdivided and the land passes out of Indian hands at allotment. Those allotments can lose that right if the water right isn't diligently pursued. Those rights can also be lost through forfeiture. If somebody was using the water at that time and then they stopped using the water, those rights can be lost. There's some indication that that the natural resources rights won't be lost in this way. And that's from that U.S. v. Adair case about the Klamath tribes in Oregon. But it's not totally decided. And then another key limit to winners' rights is the ability to transfer the rights. It requires a special act of Congress to transfer rights held in trust, and these are trust rights. So those are some of the limits. There is the overview of the 3 key types of water rights in California. Does anyone have questions? Is that all clear?
Hi. The question of the Klamath tribe and the reserving of their rights, and at least the things I read in the paper, they talked about the survival of the fish, and that was how the amount of water was determined, or about the seniority of the rights. Is that correct? And was that part of the court's decision on those rights?
Yes, absolutely. The rights were they have many different types of rights, the Klamath tribes, but the fisheries rights that they have. So this is one of those cases where their primary purposes of the reservation. So agriculture was one, also a continuation of existing hunting and fishing was considered a purpose. And so there was a recent court decision in an adjudication on the Klamath rights in Oregon, and the amount of water needed for the fish that were important for the fisheries was a key component of that decision, and of quantifying what the water right was. And they've actually, I believe 2 years ago, made calls on junior water rights when there wasn't sufficient water to support the fishery. So, and that was why it was for those purposes.
Just a couple of short ones. One is for appropriative water rights. Can the water rights change hands once either the person who applied for them passes away or the land is sold?
Absolutely, yeah, good questions. They can, they pass with the land unless there is a statement, unless there's an intent otherwise. And so when you sell the land, it will go with them. When someone passes and the land goes to the heirs, then the heirs also get the water right.
So that's the same with riparian rights. So riparian is tied to the land, but appropriative sounds to be tied to the land too, as long as the use is the same and doesn't go outside the boundaries.
Yeah, there are, yeah, the sort of the core of riparian rights is about the land,
Right.
and with appropriative rights, that's not as much the core of the right, but it is still, it does still travel with the land, but it can be separated, unlike with the riparians. So I was saying, unless, when you sell the land, unless there's an intent otherwise, the water right goes with it, but you can have an intent otherwise, unlike with a riparian right, where you can't actually separate it from the land.
Okay, so then my other question is, in terms of just when you were speaking about appropriative rights and how the person has to develop it and put it to beneficial use and report on it, although you didn't really get into the reporting of it this presentation.
Coming up, yeah.
So from what I understand, it is pretty much all on the honor system, and maybe you'll go into this in your other presentation. So, so maybe please talk at some point about at what point does the state actually look at how much water is being used and how it's impacting other beneficial uses, maybe some uses that haven't been stated, such as spawning and I guess the natural resources uses that that you're kind of referring to.
Absolutely, that is, you are almost like a plant for the segue into the next, into the next section.
Yeah, I wanted to ask about the appropriate process on these water rights for pre-1914 and pre-federal recognition for California Indians who were separated from their riparian rights on their rivers without adjudication. What is the process now for our rights?
So the next section talks about the different ways to assert and protect your rights, I think it might make sense to go through that, sort of look at the different tools that I'm going to be discussing, and then circle back around to see, to think and discuss more about, okay, how do these play out?
Right.
I think that would make sense.
Yeah, and I want you to think about what the state's responsibility is to our water rights and not pawn it off on the BIA.
I have a question about how the law that protects rights sees the word use. And because we're talking in this context, it's perhaps a unique use for tribal people, but is there anything within the framework of the law that could protect water rights that are more relational and restorative? And what I mean is to speak on behalf of water, to restore its life and its abilities because it is important to the people and in the long run for everybody else too. The condition of that water and where that water can go, et cetera. And when I say relational, part of being uniquely that tribe, you develop relations with things, and definitely water is an important thing. And with the abusive use of water, sometimes those springs or that estuary or the river itself or places you go for help or for ceremonies are interfered with. And is there a place in the law where use of water can be restorative and relational, not just what you can extract from it or how it could work for you?
So, as you can imagine, our legal system is not particularly built around concepts like that. There are a couple of inroads to that are, there's more of that in water law than there are in many other types of property law, which is one of the reasons why it's so interesting and why I think learning about water law can be worthwhile, even as a larger goal might not be the thing that fits most easily within the legal framework that exists. So in the third part of this presentation, it's going to focus on in-stream flows. And I think that the areas of the law that are most amenable to that, given that the larger structure of water rights law is not set up for that at all. So the places that are most amenable to that are going to be in the third portion of this presentation.
But it won't be attached to rights.
Not necessarily attached to rights. Yeah. Could be attached to rights, could not be. There's some underlying principles, the doctrine of public trust and the doctrine of waste and unreasonable use sort of undergird the entire water rights system in California. And we're going to talk a little more about, what are some examples of when those have been recognized, how did they come about, and I think that will be useful in thinking about where these important relational qualities of the law and of tribes' relationships with water, I think those are going to be a very useful place to start thinking about it. But I don't want to stand up here and sugarcoat and say that's the core of what's going on. I think everyone in the room knows that that's not the core of what's going on, because you wouldn't be here if things had been set up that way, right? I mean, so.
Okay. Unfortunately, I have several because remember I reserved.
Yeah, no, excellent. You don't have to reserve. unlike
But
most things in water.
the first thing I want to ask is, let's talk about who designates who has a water right.
Mm-hmm.
And the Water Resources Board actually issues permits for. Do you guys designate and identify who has the water rights? You make the list, you control, you assign water rights to specific people, you revoke water rights from specific people if they don't use them. Is that what your function is?
So that is our function for a portion of the water rights in the state. So we talked about the appropriative rights, and then we talked about pre-1914 and post-1914. So the Water Commission Act was 1913, went into effect in 1914. That is what established that anybody anywhere has to write down anything about their water and have to get any kind of permission. So to the extent that people need permission because they want to exercise or create a post-1914 appropriative water right, that needs to come through the State Water Board. And the State Water Board can make decisions about who's going to get that water right and what can they do with it.
Okay, good.
I'm going to talk a little bit I'm going to talk a little bit later and in this presentation about and then under the part 3, so the in-stream rights, we'll be talking some about some other areas where the State Water Board has some limited authority to do other things. But so in this upcoming presentation and then the in-stream section, we're going to be talking about there's some other places that we can go to get those. But actual, like, we're going to hand you a piece of paper that has all the details about what your water is, your water right is. That's just post-1914 appropriative rights.
Right, that's
Okay.
the only one I'm going to address now, because that seems to be the part of the real big problem at the moment. I mean, some of the pre-19 one, the settlement contractors, those kind of stuff, that's something else. But for example, let's say the CVP, Central Valley Project. Now, the State Water Resources Control Board actually issues permits for Bureau of Reclamation and federal things in order to utilize that water and control it and stuff like that. So if they don't do that in a beneficial use way or a public trust way, then you actually have the authority to possibly revoke that permit. I just want to put that out there, guys. And like over on the Trinity and the Klamath, the same thing is relevant to that. If they are not using their management of the dams and the releases of water, in accordance with the law and the cultural needs and those kind of things, that you guys have the ability to revoke the permits that you've given them in order to manage some of that stuff? Because that, again, would fall under the beneficial use and public trust and that kind of stuff. I just want to put that out there. So now back to, then it becomes a question of, right now in California, water allocations based on permits or allocations that the State Water Resource Control Board has done is over-allocated 5 times than what could even be produced in a very wet year. And knowing that, and not even talking about the pre-1914 stuff, we're talking about the stuff that's killing us now. Why would those allocations and those permits be done knowing that they can't be fulfilled, even if the permit says that this does not guarantee you a right, why would you do an allocation of 5 times more than what could be distributed? Because then it comes down to a situation to where the people that have those permits or those allocations, now they go to voters and they go to public local water boards and say, we have these allocations here, but we never get any because there's not enough water. So now what we need to do is make more storage. We need to do more off-stream dams and stuff like that. And that's part of a problem that's been created by the State Water Resources Control Board because of over-allocation. Then we get to the point where we have, like the example you had for a 1910 water right and a 1940 water right. You have a community who's building, they have their 1910, 1940 water right. You have a community that's building. They decide to double in size like somebody tried to say. And now that they've doubled in size, they have to have water allocations in order to take care of those families and stuff, which would impede or impair the 1910 one because of drought systems like this. But they have been given permits for that construction on water that's not going to be available in the first place. You know, and I have other ones, but I'm going to leave it there because I think I made my biggest points to start with, and then we'll talk about defending and stuff here later on.
Okay. Yeah, I think, you know, this presentation is going to talk about ways to bring issues like that up and what avenues are there. So, yes. Oh, sorry.
Oh. Well, another thing, well, it's statements, basically. I believe that you currently have 12 resolutions from tribes, federally recognized tribes right now, supporting and requesting cultural beneficial use designation on all the state water quality regional boards. And so I would just encourage tribal leaders to move this through resolution. And as the State Water Quality Control Board receives these resolutions requesting cultural beneficial use, and like the gentleman was talking about, allocations to fish and wildlife, because we lived a subsistence lifestyle, those are really, really important. And the 2 federal clubs that we have as tribal governments are the Endangered Species Act and the Clean Water Act. And what we're facing in northeastern California is the ranchers and the farmers do not want to comply with EPA regulatory requirements. Subsequently, we were going to get our river changed on the Pitt River to seasonably warm through a 303D designation. And that's what threw us into this and realized we hit ceilings everywhere. So I just really encourage tribal leaders to request consultation and to file resolutions in regards to cultural beneficial use. And for the Win-2-Winnemem, it's sacred site protection. We have federal departments that have declared sacred site protection. A lot of our cemeteries, our fish and wildlife, our cultural beneficial use way of life depended upon our waterways. And it's going to take all of us coming together. Water is the blue gold in California. It is a commodity. Huge money pushes this. And we had better come together right here, right now, or we're going to lose the West all over again.
Okay. Oh, this question is related to what Gary was talking about. When BOR did their feasibility report for the raising of Shasta Dam, they talked about actually creating new water rights because of the added storage. And you know, I don't know if that's really true or not, but so the question is procedure. You know, what does the Water Quality Control Board, what would their procedure be to determine if there is actually unused water in the Sacramento River system that they could allocate as water rights and for the state or for BOR, you know, to use? Do you do a whole system analysis of all the water rights on the river and kind of add them all up and see, well, this is how much we have and this is how much, you know, we could allocate? Or is there other, and then do you have a procedure as far as the board, as far as a public hearing, to determine those water rights, and timing also. You know, again, just repeating what Gary's saying, for BOR to go ahead with plans on raising the dam and getting, you know, congressional authorization for it, wouldn't it be, it just seems like wouldn't it be better to go to the state regional water quality, to the state water quality control board to see if those rights that BOR is talking about are actually even possible for the state to hand out?
So I think the crux of your question, I think there's sort of two main thrusts of it. And the one is sort of what procedures are there through the State Water Board to participate in decisions about water rights. And the other is, in general, how do we end up with having water over-allocated in the water rights system, and also, you know, in most years. And so the first part about how to bring these problems up, that's the crux of this next part of the presentation. I'm going to go ahead and put this up so that people can see what's coming. And then the larger question of allocation, the engineers here do an analysis of every new water right application that comes in, and a basic part of that analysis is there water available? Now, there is no average water year in California, as I'm sure you're aware. We have wet years and dry years, and really wet years and really dry years. And then we have, if you look at an average of all of those years together, water rights are handed out on the basis of there will be water available in a very wet year. It is, and then sometimes people do end up relying on those water rights for very hard needs, even though it's not a logical decision to rely on something that you're going to need every single year when you know you only have a right to it, 3 out of 7 years, based on a historical average, which may or may not prove to be the same pattern that gets followed in the future. So these are, we spend a lot of time, the division, not me personally, because I'm a lawyer, not an engineer, but the engineers down in the Division of Water Rights spend a lot of time looking at issues of, is there water available, and making that determination. And sometimes water rights applications are turned away for lack of water availability, and sometimes they're not. And we've tried to move away from giving municipal use that can be so hard, and by hard I mean inflexible, and for setting kind of a higher standard for water availability for that type of use. But that is a problem.
Yeah, I believe that, like, for the federal government to carry on a project like raising the Shasta Dam, they would need actually the blessing and permission of the state to say how that dam is operated and where that water goes and who gets that water. And so I'm wondering, has the Bureau of Reclamation made that application to the board? Are they planning to make that application soon, or do you know if BOR is just going to go right to Congress and try to get the authorization prior to receiving the permission and blessing of the state?
I don't actually know. what is happening with Shasta Dam. Yeah, I can, if you give me your card or your phone number afterwards, I can put you in touch with people at the division who would be the most likely people to be working on that particular project, and make sure that you are in contact with them. I'm not assigned to that project. I don't know if any, I don't even know if there's something before us for someone to be assigned to at this point. You know, I mean, that's, you know, no one has given it to me. So I don't know personally, but I would be happy to pass on the name of someone who would know. And in fact, I think they're going to be here at the one of the things later today. Okay, one more.
You utilized Winter's Doctrine to define the federal reserved water rights for tribes. And as you described the Winter's Doctrine case, it was based on a treaty tribe. And you described most tribes within California, for the majority, aren't treaty tribes. So in describing your limitations of Winter's Doctrine, Winter's rights, you said you must be from public domain. And I guess because many treaty tribes would have land from public domain. But the majority of tribes in California don't have land that comes from public domain. It was my understanding that tribes that have rancherias or reservations formed post-public domain would have their water rights, reserved federal water rights, determined on the time of formation of that rancheria. So is it just a later date, or is there no federal reserved right at all for these later tribes?
So the federal reserved right only comes at the time the land leaves the federal domain. So that means that a lot of tribes in California, even the federally recognized tribes, do not have Winter's rights.
But is there not other federal reserved rights not based on Winter's Doctrine? Winter's Doctrine is the most common doctrine, but can you not determine reserved rights for a tribe on other bases?
Right, so let me flip back here. Yeah, the otherwise you're all out of luck is, you know, many people are out of luck. I think a lot of people look to this doctrine and want to understand the outline of this doctrine because it is the doctrine that is rooted in a sense of land. It's rooted in the history of tribes and the history of tribes in conflict with the United States. It's in the history of reservation formation. A lot of people want to look to this, but because of these limits to Winter's rights, a lot of tribes are not going to be able to look to those in California, and particularly in California because of the treaty issues.
But
is
there later court cases that might be utilized?
I'm sorry?
Is there later court cases that might be utilized for tribes after the Winter's Doctrine?
So there is a case. Let me just speak to the treaties first. There's federal case law that clearly establishes that an executive order reservation is going to be treated like a treaty reservation for the purposes of this doctrine. But that does not mean that if the land did not come out of the federal domain at the time of creation of the reservation, that a federal right sort of springs into existence. These are called federal reserved rights because they are reserved to that land at the time the land leaves the federal domain. Now, this is my best interpretation of the law. This is honestly what I think the federal law is at this point. There are academics who argue exactly what you're saying, that based on a larger sense of justice and based on the fact that tribes were prevented from having treaties with the United States, that there should develop a new aspect of federal law that does not currently exist, that extends a water right, like a winter's right, like a federal reserved right, to lands that did not come straight from the federal domain. There has not, that is an academic conversation of where some Indian law scholars would like to see the law go. And they're coming up with reasons to take it there. That is not the current state of the law. So when I said I'm giving a presentation, it's different from the presentation 20 years ago. 20 years ago, I wouldn't have had this idea, maybe 30 years ago, my math's not all that good. But pre-Cabaret, I wouldn't have had this idea about primary purpose, secondary purpose. I wouldn't have had this limitation. Right now, there's nothing that says lands that didn't come out of the federal domain get this right. Right now, there's case law that says you have to come out of the federal domain. This right only makes sense in that context. There are people that want to push it in another way because, as you can tell in the law, there are all these different tensions. This law is coming from a lot of different places. And particularly, that's why I went through in Winners. It's not just because I'm a lawyer and I love talking about cases, but because the logic behind that, that's why people are making this argument, because it's not just based on what technically happens with the land. It also has these kind of broader ideas about justice in it, but that's not the direction it's gone so far. So right now, these are the limits to winners' rights. Yeah. Interestingly, that has not been determined. I actually would not say that. I think that the HOOPA, yeah. No, I actually would not care to speculate at all about who might and might not have a winner's right, because I don't know the depth and the individual history. The reason I'm saying I think HOOPA might, and I think UROC might, and I think Karuk might, is because there's a Solicitor General opinion out there that says that the Solicitor General of the United States thinks that they might have those rights. Even though they're not treaty tribes. So it's not about the treaty, right? So it's not the fact that it's a treaty. It's a fact of where the land came from, right? So there's nothing about the fact that these are executive order reservations that means you can't have a winner's right. The issue in California is, for I think a lot of tribes, is this purchased land issue, which is related to the treaty issue, right? Because if the treaties had been ratified at that time, then these lands might not have been moved out of the public domain and moved on to other purposes. So the issue isn't the executive orders. If the Solicitor General thinks that these tribes have a reserved right, they probably have a very good reason for thinking so. I haven't dug into the history of most tribes in California to know, and these are very specific questions. Remember, this is a broad overview. And you really, when you're looking at your winner's right, you want to drill down. A lot of tribes have some lands that were purchased and some lands that were reserved and some lands from the Bureau of Land Management and some lands from the Forest Service, and they'll still have their Forest Service reserve right and they'll have their BLM reserved right, and part of it might have been from the public domain, and you can have this whole hodgepodge. So it's going to be a very individual inquiry. So I want to let people know about these rights because people want to know about them and because they can be very important for people. But I also want to be very clear about the limits of the law right now, and that there's a reason why this hasn't been a huge force in California water. So we're like 5 minutes until lunch break. So if I may, Gita,
Yes.
I would like to propose
Okay.
talking about the first couple of slides on filing statements of water diversion and use, and then coming back fortified after lunch to start talking about what are the processes that are out there in the law at the State Water Board and outside the State Water Board for asserting and protecting these rights that we're talking about. Does that sound like a good plan?
sounds
It might
good.
run us like 5 minutes over.
Which
Hopefully not.
You have till 1:15 for lunch. We have allowed an hour and 15. So if we can dig into that lunch hour a little bit, I think we'll be fine.
I'm not planning to dig too far.
Okay, go for it.
All right. So I'm not going to that question slide again. So the filing of, okay, how to assert and protect your water rights. So I'm going to talk about 4 main topics in this section, 3 of which you're going to have to remember until after lunch. The first is going to be filing statements of water diversion and use. And this goes to the question of you have all these rights out there and you haven't said that anybody has to know what anybody else is doing. And so this is our main tool out there for knowing what anybody else in the state who doesn't have a post-1914 water right, for knowing what they're doing with water. Then we're going to move on to talk about 2 administrative processes in front of the State Water Board in which tribes can engage without raising any sovereign immunity issues. This is the complaints process and the protests process. The complaints process is to raise concerns about diversions that other people are doing and the effect that these diversions are having on the environment or on your water rights. Then there's the protest process, which is a process to engage in decisions that the State Water Board is going to make. So you were talking about is there going to be a water rights process for Bureau of Reclamation on the proposed raising of Shasta Dam? The protest process would be a way to engage in that if they do come to us with a water right request or a change request for the water rights that they currently hold. Judicial processes, so the State Water Board and the judiciary both can take the first crack at water questions. But adjudications ultimately, even if the first crack comes here, ultimately are decided in the court system. So you remember Donna's presentation, we're under the governor, so we're over here in the executive branch, and the court systems are off over there in the judicial branch. And so adjudications, there are 2 types of adjudications, ones that start here and end up there, and ones that just end up there, and then sometimes get referred back here and then end up back there. But we're going to talk about adjudications, and then we're going to talk about individual lawsuits. And then we're going to end with just a brief mention of cooperative agreements, which is where a lot of water rights issues end up in California because, as you can tell, they are very, very, very complex. And after we go through the processes to assert and protect your water rights, you will see even more why people end up with cooperative agreements instead of going through these processes. So this is a key issue, is that your water rights do not protect themselves. So there's this statement out there that constant vigilance is the price of liberty. And you can say that constant vigilance is the price of asserting a water right, too. Water rights holders are the key players in protecting water rights. Now, part of this is the nature of water rights themselves. If you aren't currently using the water, you can't stop other people from using it. It's not like your car. You can just park it in your garage and not let anyone drive it around. So if you're not driving it around, somebody else can drive it around. And the fact that you might be able to use that car some of the time, well, if nobody can tell that you're wanting to use it, then it can be very hard to say, no, 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 no. This has to be, you know, we need to do X, Y, and Z to protect this water. Lack of information. I think again, it's come up. It comes up in any sort of basic looking at what are water rights in California. How in the world is anybody supposed to know what's going on? You have these river systems that are hundreds of miles long. How are you supposed to know what is a good amount for you to be using on your riparian right, sharing with somebody who's 200 miles away, who you've never seen and you've never met? And how are you supposed to know whether somebody in the meantime had an appropriative right that might be before yours, even though it's riparian, but it might not, and you don't know, and how much can they use it for anyway, and is what they're doing legal? And there's no one place that has been collecting information on these water rights to even know what people are using. You never mind whether it's legal for them to be doing that. But what are people even doing on the ground? That information, it's not centralized out there. And then there's the State Water Board. And I was asked to comment on our role to protect water rights. That is one of our roles. And I'm going to lay out for you the systems that we have. That is one of many responsibilities that the State Water Board has. And we have to prioritize what we can do with limited resources. When I first gave this presentation, I think we had 5 or 6 people in the entire state to do water right enforcement. They've made a huge commitment. The state, the legislature decided that wasn't sufficient. And I think they're now about 30 people for the entire state to look, you know, at water rights, and to look at potential illegal diversions. So, you know, there's been a lot more focus on that recently, but it's a drop in a bucket. The water rights holders are the key to protecting water rights. So now we're going to go to the more mundane topic of statements, of water diversion and use. So in 1965, somebody realized it would be a good idea if there was one place that everybody had to at least say what water they'd been using. So they passed a section of the water code, 5100, and a few sections after that said, okay, if you use water in the state, you have to tell the State Water Board what you've been doing. And by the way, nothing can ever happen to you if you don't do this. There will be absolutely no consequences. If you don't tell the State Water Board, we'll make no assumption that you haven't been using water. We won't make an assumption about the legality of any sort of use. We won't go after you if you tell us a number that's just completely ridiculous. In fact, absolutely nothing will happen. And absolutely nothing is exactly what happened. Almost nobody filed statements of water diversion and use. And in fact, huge areas were just written out of the law. Like it wasn't even, it wasn't even a recommendation that whole areas of the state write into us and let us know what kind of water that they've been using. So 2009, this changed. The Section 5100 was strongly changed. And now a lot of the exceptions were taken out. And now people, even if they're diverting under a riparian right, a pre-1914 right, they have to write in and let us know what water they have been using. And then there are consequences if you don't. And it doesn't apply from very small springs that don't flow off of your land. And it doesn't apply where there's a water master running everything anyway, and they're telling us what's happening. Well, you don't have to tell us also. And then there's certain diversions that we get information on from other places. And again, you don't have to report again. Is anybody here from Riverside, San Bernardino, LA, or Ventura counties? Okay. So, and then this website is the link for the Division of Water Rights about statements of water diversion and use. So I said it applies to everybody, right? So what does that mean for tribes, right? Because it's a state law, right? So you have your federally recognized tribes. It doesn't, it applies to reservations to the extent that state law normally applies, which is a really clear answer. What I would propose is that regardless of whether this state law applies to the extent that somebody could go after you and do something about it if you didn't file, that it's a really, really good idea to let the State Water Board know what water you're using. Because if it's not in our computer system and we don't know it's there, it is very difficult for us to protect it. So this is a main way to let us know about a claim to water rights. And this can get you on notice lists when people come to us wanting a change to a water right or wanting a new water right. We let everybody that could potentially be affected by that change or by that new diversion know. If you filed a statement with us, then we know you're one of those people. If you don't file a statement with us, we don't know. We don't know that you're using that water. We don't know that you would like to be using that water. So please, please, please file your statements of water diversion and use. There's no sovereign immunity issue. It doesn't mean we're making a decision about the water rights. It doesn't subject the water use to our authority. And there are no fees with filing a statement of water diversion and use. So please do it. It helps us out a lot, a lot, a lot. Nope, don't have to be federally recognized to file a statement of water diversion and use. You just have to divert water and use it. Yes?
What role does State Water Resources Control Board have protecting the Public Resources Code 5093, which deals with wild and scenic rivers and streams in California? Do you guys have any role in if there was going to be any impediments done on those diversions off of those, or anything that would impede those designated wild and scenic rivers in California?
Any diversion from any water in California, any surface water, has to come from us if it's an appropriative right. If it's a riparian right, we wouldn't have permitting authority over it. We'll talk about these vaguer undergirding things later. Let me just finish up with these 2 slides, and then I'm going to let everybody go to lunch, and I will stand here and answer questions until 12:30 when I have a phone call. Please file your statement of water diversion and use. It lets us know that the right exists and that we can take it into account. It's a claim. It's not a confirmation of a right. This also means that when you go into our ERIN system and you see all of these statements of water diversion and use that people have filed, that's not saying that we think they have a water right. We're not expressing any sort of an opinion about those water rights. We're just saying, hey, when we look at what's happening upstream of here, these are people that are going to be affected. And this is a beautiful graphic of what you will be filling out, because I know that everybody is now really motivated to let us know what's happening. All right. And now I think we can break for lunch.
Okay, so just a quick, just to let you know, downstairs in this building, there is a cafeteria. They do not take ATM. There's a Golden One machine around inside our lobby. There are lots of restaurants around. You have an hour and 5 minutes. We'll resume at 1:15. Thank you.